President the power to suspend entry of limited groups of people for limited periods of time when there's a good reason. Now, of course, the question is there really a good reason right now to do this? But under that power, we think that he does have the authority to block new people from entering the U.S. So with this being non-immigrant based, and we're talking about the COVID-19 situation, we may expect that non-immigrant visas holders could be blocked from entering the country. Now, I don't expect this to have any impact on those inside the U.S. or processing with USCIS. For either H1s or L1s, the biggest impact will be felt by people outside the U.S. who do not currently hold these visas, who are waiting for their visa interview appointments.
So I believe now there are some technical difficulties in the audience, in the audio. Now we will be able to be more audible. So you're telling that this will be, if the Trump is going to pass an executive order, it's going to be only limited to the people who are about to enter into the country, but not for the people who are in United States.
Correct.
By the way, most of the consulates are already closed right now. It's only, so if the people who are stuck outside the country may be stuck for a while if there is an executive order that will be passed. What are your expectations? I know you said that on April 21st, when the Trump tweeted on April 20th night, you did said that that you presented in the YouTube video that you may be expecting the things to block the non-immigrant visa people to come, certain class of non-immigrant visa people to come in. Especially in the April 20th tweet, the Trump administration said that he may block the employment visa people to come into the United States, or so. So you said that in April 21st and also on May 26th. What do you feel? Do you think so he's going to do it, or what do you feel he's not going to do it?
I mean, based on everything that has happened to this point, I do feel that it's very likely that another executive order is coming that will suspend the entry of H1 holders, L1 holders, possibly J-1 visa holders, based on the economic and the job situation for U.S. workers. The whole, idea behind this is when we have high unemployment rate in the U.S., we should not be bringing in additional people to compete with U.S. workers. Whether we agree with that is, if that's a good idea or not is not the issue. It's can he do it, and is he likely to do it? And I do think there's a good possibility that another executive order is coming that will block entry for employment-based immigrants.
So, okay, so will he give any notice in advance? How is it going to work out? Can you give a history of the previous executive orders, what he did, how much advance notice he has to do? Since we have some technical difficulties, you have to speak more loudly.
Yeah, so, when the April executive order came out, our advance notice was a tweet late at night, and then a few days later, well, maybe a week later, right, we got the actual executive order, and that executive order took effect, I think, the following day at midnight, or there was a day or so. So I would expect the same. We've been talking about this other executive order since April. Some of the rumors right now, and I don't have any knowledge of whether they're valid or not, but they're suggesting it might be coming out this week. We thought it might come out Memorial Day weekend. I don't think anybody really knows when it's actually going to come out, but it is likely to take effect relatively quickly. So if you do have a valid visa and can come back, if travel is an option, if you get a ticket, you may want to consider coming back sooner rather than later.
What about the H4 visas? Will they be limited too, since it's working? Because all H, L, and J visas are maybe work visas. What about the H4s?
That's a good question. I haven't really considered that. I do think it's likely, because if the H1 holder, maybe if the H1 holder is already in the U.S. and it's the H4 who's stuck outside, maybe they'll be exempt from it, because I feel like in the immigrant visa ban, there were quite a few exemptions for people who are already had the visa stamped but had not traveled yet, for people who were specific categories based on your marriage to a U.S. citizen or to a green card holder and all of those things. So I think there's a likelihood that if the H-1B holder or the L-1 holder, the main principal applicant, is already in the U.S. and the spouse is outside the U.S., maybe they'll still allow you to come in, but I don't think anybody knows for sure right now.
So Emily, on the visa appointments though, right now all the consulates are closed. It seems that the consulates that are open right now seems to be taking an appointment. Initially the consulates said it's June, and now it's August, and who knows, they may postpone it for a long period of time. What's going to happen with all the student visa people who wants to enter the United States? And their admission, the colleges are going to be open in time, and a lot of colleges have already announced that they're going to conduct the live classes, not the Zoom classes or so. What's going to happen with all the student visas? Not only student visas, the H-1B visas who are going to get the H-1B approval with the premium processing, and a lot of other visas. Where are they going to go for stamping? What is going to happen with them?
Yeah, it's a tough situation, and I think at least with this aspect, the issue is the virus. Is it safe to reopen consulates and have face-to-face interviews? What precautions do they need to put in place first to make those happen? I have had a few people that have been able to get appointments in July. Right now, those of course might be postponed. We know with the the local offices here in the U.S., they were supposed to reopen June 4th.
You're speaking of the application support centers.
Right,
okay.
And that hasn't actually happened that way. So it's very possible that people may have difficulties getting their visas to come in for the fall semester for school, and they may have to defer until they can get the visa. I would expect universities will be banding together and reaching out to Congress, reaching out to the administration to try to compel them to open the consulates, because that's a huge income factor for many universities and colleges across the country, is that tuition coming in from international students. And so if new freshmen and new people for master's programs are not able to come in, not able to pay that tuition, that's going to be a huge monetary loss.
According to the survey, approximately 5% of the students in the United States in the university are actually foreign people. So if they are not able to open the consulates, that looks to be a disaster, though. So something can be attributed to the administration. Some things could be attributed to the COVID situation too. Is this administration trying to make an excuse to get rid of all immigrants? Is it making they're trying to make COVID an excuse to? Anyway, this administration doesn't like it. They focused more on undocumented aliens when they came into power, but seems to be that they filled out all the top positions of the USCIS, and all those been filled out by the people who hate the immigrants and the business immigration also. Are they making COVID an excuse to stop the whole thing?
I think most definitely. I mean, it gives them a great opportunity to where they can blame it on the virus, but still get the ultimate result that they want, which is less immigration, whether it's legal or illegal immigration. This virus has effectively limited it, and so they're getting what they want, and they're able to blame it on the virus rather than anti-immigrant policies.
Emily, we have received letters from the consulate that the non-immigrant visas for the people who are on F1 visa have been revoked. This comment came out actually last week. We were not there. It was Rebecca, and we just ignored it. We asked, normally the people who have a DUI, they get their visa revoked, the student visa or whatever visa it may be. They get their visa revoked, and that doesn't mean that they are illegal. They can still work. They can continue doing whatever, and when they go outside the country, they have to get the stamping before they come back. Now all of a sudden we receive people, and initially I thought, I asked the person on the YouTube whether he had any issues with the law, any criminal record. He said no, absolutely. Obviously he's not going to, I thought that he's not going to admit it in the YouTube and Facebook Live, but then starting next day we started receiving these emails from the people saying that their visa's been revoked, and I spoke with them. They don't have any criminal record. Can you explain what happened on this?
Yes, so we looked into it, spoke with them, tried to figure out, this is a large number of people, and tried to figure out what the common denominator is that would cause multiple people to all have their visas revoked at the same time. And it basically boils down to some companies in the US were fraudulently issuing offer letters to these students so that they could use them in order to obtain their OPT or their OPT STEM extension. So the offer letter makes it look like you have a job offer or you're going to be employed so that you don't reach your unemployment limit. And some of these students were submitting that to either the DSOs or to USCIS in order to receive their STEM extension or to receive their H-1B visa approval. Well, those offer letters were not real offers. So after apparently some investigations have been done, the consulates made this determination and decided to revoke the visas based on these fake offer letters that were
Do
issued.
you know the names of the companies that are involved in it?
Yeah, so this appears to be Integra Technologies, which, looking back, when we go and look at the SEVP and ICE data that's publicly available that talks about which companies are receiving the most OPT students and STEM extension students, it's number 2 on the list. 2,000 STEM students are, supposedly working with this Integra Technologies, and it appears to be all fake. They were just issuing offer letters and the students were paying them for it. The other company is Aztec Technologies, which is also top in the list for the number of students employed at those companies, but they're not actually
Are you telling that Integra Technologies is the number 2 in the entire list of the people who are utilizing the 2018 according to the ICE?
Mm-hmm. Yep.
Which is number 1?
Amazon.
Which is number 2?
Intel,
Number 3, sorry.
Intel and then Google.
You mean to say this particular company is ahead of Microsoft, Google, and Intel in utilizing the OPT, and that's surprising. So, and Aztec comes next to Microsoft according to the list. You guys can find this list. It's if you type in the 2018 top 200 employers of OPT and STEM extension OPT, you can find this list in the Immigration and Customs Enforcement, and you will be able to find out this company. I will read out the top companies that are utilizing, and you can, most of you guys, I will be very surprised any of you guys don't know some of these companies that I'm listing. Amazon is number 1, obviously. They do have a lot of people that employ. Integra Technologies is number 2, ahead of Intel, Google, and Microsoft. That surprises me is that after that is Intel, Google, and Microsoft. Then comes Aztec Technology. Then comes Deloitte. Then comes Facebook. This is completely, there's something completely we missed out, or the whole people missed out. Now they are getting the people who have ever used the experience letters of the Integra and Aztec Technologies is the people who have actually been getting the revocation notices of their visas. Now, it's not going to be over that their visa will be revoked. There is a very high chance that they'll be hit with a misrepresentation. They'll be permanently barred from United States. Their waivers are applicable for only limited people, and those people are if their spouse is a US citizen or if their parent is a US citizen, and that too waivers are very rarely granted for misrepresentation. There is a chance that the ICE, if they are in a student visa, their service might be suspended. In fact, I have received information that they started revoking the OPTs and STEM extensions if they're already here. They will be revoked, and there is a chance that the ICE might take these people into custody. The number of people who are affected in this one, according to the stats of the ICE, is 4,600 people. The Integra Technology seems to have different names of the company. That is one name, Integra, but there are also other names. I don't want to name unless I'm very clear with those names. But there are other names of those companies that have issued letters. This is a very major issue in immigration. If you present a document which is a fraudulent document to obtain any immigration benefit, that is considered to be misrepresentation. Misrepresentations can be two. Let's say, for example, a misrepresentation that may not be material, might not cause some damage. For example, if you were giving your, instead of giving 235 as an apartment, you have to give 335. That apartment number, because you're living in both the things, maybe your driving license is here, you have other things, that may not be material in getting you the OPT or STEM extension. You may get away with that particular misrepresentation. I'm not telling you should do it, but I'm just telling there's a chance that you might. But if you're providing a document, an employer letter, to get an immigration benefit, to get the OPT, you need an employer letter. To get a STEM extension, you need the 983 to be signed. You're documenting saying that you have an employment with that particular company, you have training with that company, then you are definitely a misrepresentation, and you have a good chance for you to get hit with the misrepresentation and permanent bar into coming to the United States. Now, after speaking with the people, we came to the conclusion that I spoke with about 17, 18 people from either of these companies since past 1 week. I came to the conclusion that this company, Aztec and Integra, have charged money in issuing these letters. They have charged a certain amount of money to issuing these letters. A person by name Mr. Chakravarti seems to be the person who's operating the Integra Technologies. When I looked into the employer letter, I found out that this person or this company may be actually operating from India rather than actually from here, though. Even though the company is registered in Delaware, though, the person of the company might be operating from India. How can I tell it? Because in India, the paper size is a little bit lengthier, though. So when they gave this letter, though, the letter size was a little bit lengthier. Also, in the address, though, that they have given, normally in India, after we write the numbers, we put a comma and write it. That's the way English people write it, and that's the way we have been taught. Like, let's say our address is 11,000 Richmond Avenue. We put a comma after 11,000 and then go to Richmond Avenue. That's where I found out that these are the two indications that this person might be operating from India rather than actually operating from here. But for sure, we can tell that the people, if any of you guys have used the experience letters from these, any of the people have any time used them as an employer, you should contact a lawyer immediately.
Yeah, and this issue could come up anytime you're traveling, entering into the country, applying for the visa at the consulate, filing something with USCIS, filing your H-1B, filing your STEM extension. So it's, I would say it's not an issue that's only if you're exiting and applying for the visa. It could come up at multiple points. So definitely be aware of that and seek some consultation.
Yeah, after this thing started, Emily, I went back and checked into my records. There was one person who was deported in March of 2020 for working for one of these companies. I also had a record that one person was working for Aztec that got for the Integra solution that got deported in May of 2020. So these are the things that our office came across that I checked in our database to see those. So there may be a lot more other instances that may happen. So please, if you work for any of these companies, I want you to contact the USCIS as soon as possible. I'm sorry, I take back, not USCIS. Contact the lawyer as soon as possible. Anything else, Emily, before we go to?
Yeah, one other thing I wanted to mention, so I briefly mentioned it earlier. June 4th, we were expecting to see USCIS offices reopening. This is very important for people who are waiting to do their biometrics. If you have a pending I-539, especially for those that have an EAD application pending based on that I-539, you've been stuck waiting for your biometrics since March. Same for those that have local office interviews for your last step of your green card or your naturalization ceremony. So June 4th was supposed to be the day that offices started to open. But if you actually look on the USCIS website, you can see which offices are open and which offices are closed. And it clearly says every single application support center across the country remains closed, even though now we're June 9th. So they are not doing the biometrics appointments still, even though they indicated that they would start reopening June 4th. Even the local offices that were supposed to be reopening, most of them say that they are closed to the public and only accepting emergency services appointments. So it looks like this grand reopening on June 4th really did not happen, is not expected to happen. It's going to be more time before people are able to complete their fingerprinting, their biometrics, and their green card interviews.
Some people are asking the link and details of this company, and you can find these details at rnlawgroup.com. We put a news section in that. I put it in the footnote. Seems to be that one gentleman from Cornell seems to have given a link for these companies for you guys to check in. Not only these companies though, I would be, if you by any chance have used any letter where it is considered to be fake, I would strongly recommend that you contact a lawyer immediately. Make sure that those people who are going forward don't do it, but if you have already done it, you should consider contacting a lawyer immediately.
All right, we'll go to some questions here from Facebook. Avinash wants to know kind of what's the status of the H4 EAD? Is that something that's going to be impacted by the executive order? So as you probably know, the H4 EAD has been planned for a proposed regulation for quite some time now. It's been stuck with the OMB for over a year and still has not moved forward with an actual proposal. It's, everybody's guessing right now at what this executive order is actually going to do. It was clear in the first executive order that the Trump administration directed all the agencies to look at what their current policies are, what regulations need to be modified for the protection of U.S. workers. So we could see an actual proposed rule come out to eliminate the H4 EAD, but we've known that all along, so that's not really anything new. We've just been waiting for it for a long time. It might be, the process might speed up, but it's not a new issue.
Tushar has this question. His wife is an H4. She has a Canadian PR. Can she work in Canada and live in USA? Can she do daily commute? Yes, you can. Technically, you can. However, we have noticed that the border people are recently kind of giving some hard times for the people who travel every day from Canada from Canada to USA, and they're asking questions. Do you do any part of your work in USA? So that definitely, especially under the COVID situation, that becomes a problem for us, because if your wife is sitting in USA and working for a Canadian company, that definitely is a violation. And the governments at this point of time don't recognize cyberspace as a space. It's only where your butt sits what counts. So if she's sitting in USA and she's working, that definitely is a violation unless she has a H4 EAD. So you have to be very careful on these things though. If it's a daily operation, that's definitely not advisable.
One of the questions was about STEM OPT. Is that something that might be targeted by this executive order? So the STEM OPT was created by regulation. So in order to modify it, it does require a regulatory process. So the question then becomes, can it be done quickly through such thing as an interim final rule or a temporary final rule? That is a possibility. The STEM extension, the 17-month STEM extension that we got back in 2008 was actually created by an interim final rule, and that's actually what caused it to be vacated and replaced by the 24-month STEM extension several years ago. They found that there was not enough solid reasoning to support the need to do that as an interim final rule. So you can't just choose randomly which rule can be done by interim final rule versus a regular rulemaking process. There has to be a solid reason why it has to be done this way, why there's not sufficient time to go through the full regulatory process. I think there's a good chance the Trump administration might try to make that argument based, again, on the COVID-19 situation and the fact that many American workers are out of a job and unemployment is quite high. If they take the time to go through the long regulatory process, it might be too late, is the argument that they might try to make. Whether that would hold up to court is a different question. We've seen many cases where the Trump administration attempts something and then courts later block it. Now, that didn't happen with the Muslim ban. They were able to do that, and that's because it's under the statute, the 212F that I mentioned earlier. That does give the president that specific power to block people from entering. So that has been tested by courts, and courts sided with the Trump administration on that. This issue of interim final rulemaking, the previous presidential administrations actually lost that argument. That's how we ended up with the 24-month STEM extension. So all that to say, of course, no one really knows what's going to happen, but I think it may be more of a difficult road if the Trump administration tries to go to an interim final rule right now.
Question from Bhavskar is that, is there any issues with the people who are in H4 people to travel from India to USA? At this point of time, there is no restriction, but we don't know if there is going to be any executive order. But when the executive order comes in, we will be able to give you more details. Is there a possibility? Obviously, as Emily has explained, the administration does have, at least they think they do have an authority to do the interim ban for the people who are coming, and that includes also H4 people also. So there is a possibility for that they can put a restriction on H4 people to come into the United States. There are a lot of speculations out in the Twitter and other things that when this is going to be coming up. Emily, do you have any projections? Now, on the actual tweet of the Trump administration, Trump personally actually tweeted on April 20th at about midnight, about 10 or 11 o'clock of Central Time. We immediately conducted a conference call, me and Emily, and there are a lot of calls, and 300 people showed up at the time for the conference call to address the issue. This is in April 20th, though. Then we had some issue on May 25th. We were suspecting, on May 26th, we were suspecting, and then we presented at that point of time to the YouTube and Facebook at the time, saying that there is, but it's very hard to speculate, though. All we can say is that if you are outside the country, if you can come in physically and safely, safely part, I would leave that topic to your doctors and other advisors. Me and Emily are not qualified to advise you health-wise, so we would not advise, and don't take our advices on the health conditions or whether or not to travel is only when we are speaking about the immigration-related things. Health-related things, you have to consult somebody else, not our office, as you know that we are not good in that thing.
Arun wants to know if there's been any guidelines issued for visitors who are here and I-94 is expiring soon and you can't travel out because of the current travel restrictions. Well, there's no specific guidelines given for that situation. Your option is to basically file an extension of your B2 status with USCIS before the I-94 expires. This can be filed online. It's the I-539 application. It can be filed electronically or you can file by paper. The benefit of online filing is you get an immediate receipt number, so if you're expiring in the near future, you can have that receipt quickly. The downside is if you have multiple family members all needing to file, if you file online, you have to pay the filing fee multiple times, versus if you file on paper, you pay one filing fee and everybody pays just the small biometrics fee.
One question that came out, what will happen to the pending applications of the that are pending if the executive order goes? As we were pointing out, the executive order is expected to be limited only to the people who are outside the country. So the pending applications are, if they are in United States, they shouldn't have any problem. Even if they are outside the United States, the pending applications will go through as they are. But the only problem is for them to come into United States after it's been approved might be limited.
Yes, so our expectation is H-1B extensions can continue to be filed with USCIS, transfers can be filed, amendments can be filed, L1 extensions, L2, H4, all the extensions or transfers or change of status filed with USCIS should not be impacted by an executive order. What will be impacted is your ability to travel into the U.S. if you happen to be outside the U.S. when the executive order takes effect.
A lot of questions on the ban of the H4 EAD, ban on the H4 entry into the United States and H1s. We may conduct a separate session especially on this by the end of this week. As the things develop, guys, there are some technical difficulties today, and normally we do this every day conference, every Tuesday, covering all the topics. We may do specially on this. Probably by the end of this week, we should be able to present it, as people are very curious on those things.
Let's see. Sanka wanted to know, she has a Freedom of Information Act or a FOIA request pending to receive documentation of her I-140 that's been taking 4 months, and is there a way to expedite that? Based on our experience, they are mostly first in, first out, and I don't believe there's a way to expedite it unless you file a lawsuit claiming that the delay is unreasonable. Probably 4 months is not considered unreasonable yet, so I think you have to keep waiting for that.
Is electronic POM applications acceptable for the I-140 process? The email copy that we receive for POM application is good enough for the I-140 processing. This comes from Paul. There were some issues initially when we filed for the I-140 application. They rejected it. They caused a lot of trouble for us because they were not educated on that Labor Department is not issuing the original labor certifications anymore. But that has been cleared right now. We don't have any problem on having our I-140 applications if we file the copy that we received from the email, electronic copy that we received. We don't have any problems at this point of time. Just to note that people, that the I-140 premium processing has already started, starting from June 1st. And on June 8th, we have the extensions, amendments, and transfer applications of premium processing has started. And on June 22nd is where, if you are in the quota, you can convert your existing application to premium processing. Or if you're filing on or after June 22nd, you can file in premium processing the quota cases.
For the extensions, transfers, and amendments, June 8th date, that's for those that are currently pending and upgrading to premium processing. If it's not already filed by June 8th, then you can only do the premium processing after June 22nd. Sohrav wants to know, the job title and SOC code says that most occupations require a bachelor's degree, but some do not. This is if you look up the code in the Occupational Outlook Handbook, which is used quite often by USCIS. He wants to know if this will have any issue for getting the PERM or I-140 approved in the EB2 or EB3 classification, since that is for professional positions. Actually, our experience is that they do not look at that for approving an EB2 or EB3. They look at what your specific employer's normal minimum requirements are. So if that minimum requirement is at least a bachelor's degree, regardless of what the SOC code says, it qualifies for EB3. If it requires a master's degree or a bachelor's degree plus 5 years of progressive experience, it qualifies for EB2, regardless of what the Occupational Outlook Handbook says. It can have a slight impact on the PERM process if the employer's requirements are way higher than what the ONET or the SOC code says. That might trigger an audit and require some business necessity for the company to explain why is it this company requires such a high level of education or experience when the normal industry standard is much less than that. But it doesn't affect your ability to qualify in EB2 or EB3 at the I-140 stage.
Dipti has this question. Can I work while the H4 and H4 EAD is pending? Because her H4 EAD is expiring. Because of the COVID situation, is there any automatic extension of the card which is expiring? The answer is no, Dipti. There is no automatic expiration, no automatic extension of the EAD at this point of time. The only relaxations that they have given for the COVID situation is if they have an RFE, the deadline falls between a certain period of time, they're allowing us to file it after the deadline is over. I don't want to give all the dates in here, but those are the only exceptions that is there. But you cannot automatically extend the EAD. They have also given some exemptions with regards to the original signature. They're accepting the copies of the signatures in some of the applications. Those are the only things that I know. Any other things because of the COVID?
Shruti had a question and I just lost it. Where was it? If you have a valid L2 EAD, but also have a pending H4 I-539 application, can you keep working? So if you are properly maintaining your L2 status based on your spouse properly maintaining their L1 status, and you have an EAD, you can work using that EAD while your I-539 application to change to H4 is pending. So just because you filed it does not mean you have to stop working. But if that H4 is actually approved and you did not also get an H4 EAD, then you would have to stop working.
Bharat has this question, is it a proper time to apply for the F1 to H1 visa status? Maybe not. One thing is that there's no appointments there. The appointments that they're giving, they keep on canceling those appointments. You have to keep on filing those applications again. Also, because of the economy right now, the consulates are been off for a while and they come back. They don't know how they're going to, we don't know how they're going to behave. I may want you to wait for some time and remember that we were discussing about the people who are stuck outside on H-1B to come back into the United States. You may get the H-1B but get stuck outside the country too. So that's a possibility. Mohammed has this question, is there a chance the TN visa can be affected with this executive order? Yeah, what do you say? There's a chance, but I would say that it's a lesser chance than H-1B and L-1 compared to TN visa, but we cannot deny that the Trump administration may not ban TN visa. There is a chance that he can do that.
Pavitra wants to know if there's any chances for a second H-1B lottery this year. So if not enough people file that were selected to where we have not filled out the cap, then the regulations do allow for a second lottery to be conducted. However, of course, no one knows how many petitions have been filed so far. You do have to realize that USCIS does select extra each year, knowing that a certain percentage are ultimately going to be denied or withdrawn. Here, it could be a certain percentage that end up not being filed. So I think they likely took into consideration the idea that some employers will be selected but not file. Maybe that number has grown because of the COVID-19 situation, but at least in our office, I would say the percentage of employers who are not filing that were selected is quite low. Most of their applications, especially in the tech industry where we have super low unemployment still, I think that likely we're still going to fill the cap based on those selected so far. That's a guess though, but that would be my educated guess.
Colonel has this question, could the Trump administration block the H-1B people from entering into the United States? Yes. How long will this order will be in effect though? We don't know. We don't know when the order comes out. I can tell you one thing, that this administration, when they block it temporarily, they tend to keep on extending the blocks for a long period of time. So they may issue for 90 days and they can keep on extending temporarily. Every 90 days they can keep on extending it. There is a possibility for that.
Satish Kumar wants to know if it's true that USCIS could make the priority dates current so people can file their 485 based on USCIS needing more money. Do you think that would happen?
To file?
To move the priority dates so that...
No, yeah, I don't think so. I don't think so. If the administration wants to make money like that, yeah, they can put $10,000 and let you file the adjustment of status. Most of my clients will be happy to file it. The administration knows that they can get the money if they want to. One other thing, if you ever want to consider that money is an aspect, that they are sucking more money from us by keeping you on H-1B. Don't forget that. Some of the H-1B fees when you transfer is $6,000 plus the premium processing fees. What are you speaking about? They are sucking money from us when you guys are on the H-1B. So no, that may not be an incentive. If that is an incentive, actually, they may actually delay your adjustment of status. Because they will make more money in you, because every year you have to file an extension, H1, H4, H4 EAD. Once you file the adjustment of status, guess what? There is no extension fees also for EAD in advance parole at this point of time. So yeah, that's ruled out completely.
Another question, I think you've answered this in the past. If someone makes a mistake on their DS-160 that's already submitted, is there a way for them to delete it or withdraw it? How should they correct that?
They can try to log in to see if they can correct it. If not, what the consulate says is that to fill a manual DS-160 form, take it with them, and drop an email to the consulate that if you cannot do it, that you did an error in filling the DS-160 form, and this is the error you identified. You take the form so that they'll be on the record. You'll be very surprised. The email works very good with the consulate, though. They will have a record of that when you go there. So when you go there, they will have that record, and then you can explain to them, look, my thing is wrong here. Especially if we have seen people who don't inform properly the consulate. You may be hit with a misrepresentation that you have filled in the wrong information, may be barred forever. But if you take these two corrective actions, one is try to log in to change. If not, drop an email to the consulate. Look, I put Harvard University, but it's not Harvard, it's actually Howard University. You can always send an email to them. You can send an email differently, whatever the situation might be. That will be on the record so that they know that you have not misrepresented, that you have officially informed. I'll be very surprised if you drop an email that they'll be hitting with misrepresentation. So you can drop an email and make a manual form, take it with you, and they will be able to correct that online on there. I've seen them, the consulates will ask you to sign the DS-160, initial it in the place where you correct it, and to keep it for the record, which is fine.
Bijal wants to know, he's got his H4 and H4 EAD extensions pending. Will USCIS require the biometrics to be taken for that approval because it's expiring in September? So if you have not done biometrics with USCIS for a previous I-539, you will have to do biometrics again. They're only reusing them if you've previously done them as part of an I-539 filing, which for the most part, not many people will be able to say that they've done that because the biometrics for I-539 filing only started a year ago. So if you have renewed within the past year and now you're filing again, you may be able to have them reused, but everybody else, they are still requiring them.
They just ask this question, can we apply for a diversity visa if you already have an I-140 approval through my employer? Most of the people who are eligible for the diversity visa, the priority date is current. I don't know why you're not filing an adjustment of status. For the people who are born in India and China, they are not eligible for the diversity visa. So if you're eligible for the diversity visa, your priority date is current. You should be current, so that you may want to check on that though.
Another question was, if I'm in the U.S. and changing status from L1 to H1, will the executive order be impacting that application? So assuming the application is a change of status and not consular processing, the application should still be processed as usual. The executive order should not impact that. But if you've requested consular processing, meaning you were intending to leave the country and apply for the H-1B stamp at the consulate in order to activate your H-1 status, you may be blocked from getting that H-1B visa at the consulate.
One question.
Abhishek wants to know if we can expect any change in EB2 or EB3 processing in the near future. If you're asking about priority dates, I don't think we can expect any differences. It's going to move forward at a snail's pace, just like it has been for a number of months now. I don't think we'll see any change on that.
Question comes from Tisha, I can't pronounce the name, but Chen, is that what's the difference between filing before 21 and after 21? But we need to know, is it like a family-based application or is it a what-based application? I'm assuming it's a family-based application. And there are two different criteria in the family-based application. Is it a immediate relative, or a US citizen, or a green card holder? There's a lot of difference between both the things, though. I would recommend that you contact a lawyer before you take any of the steps on filing under 21, because it makes a lot of difference if you file. Are you filing only I-130 or are you filing 485 also? It makes a lot of difference too.
Here's a question from Hurain that I don't think we've ever had. What exactly is supervised recruitment? I don't recall ever answering that question, so good question. So supervised recruitment is something that happens typically when an employer has filed the labor certification. If there's been an audit, sometimes after that audit, they will come back and say that the employer has to go through another round of advertising under a process called supervised recruitment. That means the Labor Department is supervising the process of the recruitment. In other words, the Labor Department will tell the employer, this is the exact wording of what you need to advertise, and this is where you need to advertise it, and they will list specific websites or specific newspapers, and then they ask the employer to reply back with what schedule they're going to follow for their advertising process, and then the employer has to follow that schedule to a T and document that they've done all of those. The other difference is that instead of job applicants sending in their resume to the employer, during this process, they're actually instructed to send their resume directly to the Labor Department, and then the Labor Department will review those and send them to the employer with instructions about what needs to be done, whether they need to interview those people or explain why those people are not qualified for the position. It is a lengthy process. It is a lot of work that has to be done, especially in our office for the attorneys. We do not enjoy the process, but the case can still be approved, but it does have a higher rate of denial. If you do one tiny little thing wrong, they will catch it and they can deny the application.
Karthikeyan has H4 and EAD extension pending. Can he leave the country and work outside the country even though the EAD has expired? If you're outside the country and you want to work, you will come under the jurisdiction on the country in which you are living, where your butt is sitting at. So if you are in India and you are an Indian citizen, yes, you can work even if the EAD expires, because you're working in India. It doesn't matter where you log in. It does matter where you are sitting at. So you can work from India if you are an Indian national. I don't see any problem in that at all. As far as the H4 and EAD is concerned, yeah, you can wait until the H4 EAD is approved and apply for the H4 stamping in India and come back into the United States.
Parag has a question about the Integra and Aztec issue. If someone actually worked for one of these companies years ago, even if it was for a short period of time, is it possible that your green card could be impacted?
Yeah.
It is. I mean, we don't know how deep the investigation goes, but generally when we see companies get into trouble, it does spill over to other applications that involve the company. So if you got an experience letter from one of those companies and submitted that with your I-140 petition, it's very possible that they may be checking into that.
And also, if you have submitted that this is the employer to your DSO, they will look into. There is a good chance for them to look into it. The ICE never used to present these evidences before. How many employers are employing these things? They only started from 2017, 2018, since this administration came in. Right now, they have a track of each employer, how many employees they have sponsored on the OPT, STEM extension, CPT, They have a track record of all those things. In fact, they published this record, and you can look it in the ICE records by typing in 2018 top 200 employees of OPT and STEM OPT students, and you can type that one out, and then you can get the information. You can also look into RN Law Group, and I'm very surprised when 2017 came out, they released all this information that they're tracking each and every employer, how many people are working for those companies. These two companies, according to us, are already tracked. The people who have ever been documented to have worked according to their records is already tracked. So as Emily was pointing out, there is a good probability that the person will be in trouble. We've been advised a lot of times that when things like this blow up, the entire thing will fall down. And that's the reason why we always advise people never to join the day one CPT. The day one CPTs are a big problem. And now you see that when things like this company falls down, the whole thing falls down. There is a good chance that they may go after. There may even a chance that they may be detained and be prosecuted for misrepresentation for the USCIS. So I would recommend that you contact a lawyer immediately.
Kamesh wants to know how long it's taking to get an L2 and EAD approved when filed concurrently. So it's based on the L2 processing time, which is the I-539. So you can actually go to the USCIS website and look up their processing times, select the I-539 as the form, select the service center where yours is pending. They are quite different, and it will tell you how many months it's taking. There are 4 different service centers currently processing these types of applications, and they can be anywhere from, I think, 4 months to 10 months is the current processing time. But those, at least for the I-539 applications, those posted processing times are pretty accurate on the USCIS website.
A question that came out here is that, is it only these two companies or any other, is it all consulting companies? Of course, it's not all consulting companies, but any consulting company, you have not received any training and you have provided the evidence and you have not worked there or you've not been provided the training, and you represented in front of the DSO and in the USCIS, definitely you may want to contact a lawyer though on that because it's very surprising. The company names that I see down the list is, I will name them as Amazon, of course, you know, Amazon is good. Integra, that's the number 2, that was in trouble. Intel is good, Google is good, Microsoft is good. Aztec, that's in trouble. And then we have Deloitte and Facebook, which are very good companies. I don't know about this XYZ Design Corporation. Did you ever hear that? Mm-hmm. And then comes the Telon Trading Inc., which was actually FBI investigated this company, Emily. Okay. We found out that FBI investigated. There are approximately around 1,000 students that got into trouble. It seems that most of the people that got trouble in Trillion Trading Inc. seems to be Chinese and Korean students, not much of Indian students. Then comes the IBM, and then comes the other companies. So, but I'm a bit wondering where do they stand for? I mean, where does it all come? These small companies, and when you go, when I looked into the company though, their location is so small. How do they employ 2,000 people in that small location? Where are they training? What's going on in these things? So if you have ever worked for a consulting company that have been issued letters to you and you never got trained, you never worked, you may be in trouble. I mean, you should be very careful. And for the people who are going forward though, don't look for the trouble companies, try to look for genuine companies. There are a lot of genuine opportunity companies that will take you in. So don't try to get into trouble by getting an easy way out. That's not advisable for you guys.
Sampath wants to know, is I-140 has been filed in premium processing? Will an executive order impact that processing? So the processing of the I-140 with USCIS is not impacted. It's an immigrant petition, so if it was going to be impacted, it would have been under the previous executive order blocking immigrant visa applications. So the processing with USCIS has not been impacted at all, and we don't expect that. If your I-140 was filed for consular processing, where you are intending on leaving the country and applying for your green card at the consulate, right now you cannot get the visa at the consulate. But assuming your plan was to file the adjustment of status, or if your priority date is not current and you can't file it anyways, the executive order should not have an impact.
Person has been posting again PUA. What is it? Do you know what PUA is? Just don't give us the short forms and ask the question, guys. You need to give the full form of it. What does PUA means? We don't understand what you're speaking, Anil. So please phrase the question properly so that we can understand it much better. A lot of questions are coming with regards to the executive order. My wife is a physical therapist. Can she be banned coming into the United States because she's a healthcare worker? We don't know yet. We don't know yet what the details are in there. There may be exception for nurses and doctors, but I'm not sure about physical therapists. In the resilient bill, though, they didn't include a physical therapist as part of the COVID benefit bill for the immigrants. So we don't know if the executive order might exempt the healthcare workers or not. We have no idea at this point of time. Anything else?
I think that's about it for today. I apologize for our technical difficulties.
Yeah, we had a lot of technical difficulties, guys, and for the YouTube viewers also, we're going to copy this and paste it in the YouTube. We're going to try to see if we can conduct another session exclusively only for the executive order, possibilities of the executive orders as things are heating up. And also for the people who are on the companies whom you have worked. There's an article written on rnlawgroup.com. Don't forget, you can make an appointment with any of our colleagues at rnlawgroup.com. Sorry again for the technical difficulties that we had today.